so I am going to be here 2 years. So, and you know, and see, my wife has this ability that she never uses, but she can veto anything I do because I don't care about you all half as much as I care about having peace in my household.
Oh, see,
Well, that may be close. That may be close.
You accept it.
No.
There's Bagby, there's your wife, and there's
Bag beat in. Yeah.
Committee on Labor and Commerce. First order of business. We have some bills that are by for the day. That's House Bill 1240. Is there a motion?
second.
House Bill 66. Is there a motion? House Bill 835. Is there a motion? And House Bill 1441. By for the day. A motion? Thank. Second. All in favor?
Aye.
Aye.
Thank you. We have also a bill that we have been requested to strike, and that's House Bill 487. Is there a motion?
So moved.
All in favor? Record your vote on the electronic vote machine.
Gotta hurry.
The clerk will close the roll. The measure passes 19-0. The bill is stricken. And now what we'll do is go through our agenda. And the first order that we have some bills that are similar, and they are proposed to be incorporated into House Bill 789. Those bills are House Bill 184, House Bill 843, House Bill 1265, and House Bill 1296. Today, we're going to ask those patrons to present their bills, and after the patrons have presented, the chair will entertain a motion to incorporate the four bills into House Bill 789. And since they're going to be incorporated into House Bill 789, we will delay the public comments to our Thursday meeting on January the 23rd on the new incorporated bill. So, yeah.
And would that mean we'd be able to ask questions then?
Yes.
Okay.
That's when. So, if those patrons, if they are here, House Bill 184. House Bill 843. House Bill 1265. Thank you, Delegate.
Thank you, Madam Chair. Madam Chair, members of the full committee, I'm here to present my bill, House Bill 1265, which requires the State Corporation Commission, as a condition of licensing a consumer finance company, to find that the applicant will not make finance loans at the same location at which the applicant makes payday loans or motor vehicle title loans. This measure seeks to set the minimum maximum amounts of consumer finance loans at $500,000 and $35,000 respectively, requires that such loans be installment loans with a term that is not less than 6 months nor more than 120 months, sets the maximum annual interest rate on such loans at 36%. It is no secret that predatory lending benefits lenders and ignores or hinders the borrower's ability to repay the debt. Predatory lenders typically target minorities, the poor, the elderly, and the less educated, and research shows that people that use payday loans are 38% more likely to have worse health than those that do not use these type of loans. Few regulations make it possible for consumers to fall into cycles of unworkable repayment rates, exorbitant fees and fines, and essentially unmanageable
I
debt.
may have to jettison 'cause this
And I believe this is one of the bills that will be rolled into the larger omnibus bill, Madam Chair.
Thank you, Delegate.
Thank you.
installment loans. Supposed to open it.
House Bill 1296. Okay.
I want to ask a question. Madam Chair,
Yes.
a question about the bills that
Yes.
were just mentioned. So the bill that they are going to be incorporated into, do we anticipate there's going to be a substitute that might reflect certain parts of those, or we will still be able to have a full discussion on that bill?
Yes, that's correct.
Okay,
We will have a full discussion.
thank you.
I see that Delegate Simon has just arrived. You like?
That's
Oh,
Levine.
Levine. You like? House Bill 184?
Yeah, I'd just like to.
I'm so sorry. I just repeated what I heard.
Thank you, Madam Chair, members of the committee. I understand that this is going to be incorporated into Delegate Bagby's very fine bill. I just wanted to chat very briefly about what HB 184 does. What it lacks in the comprehensiveness of Delegate Bagby's bill, it makes up for in simplicity, is one page. And the heart of what it does, I understand, is in Delegate Bagby's bill, which I support. But the heart of it is that it deals with open-ended credit. And it says that you can't charge interest in excess of 36%. Virginia lenders don't want to charge interest in excess of 36% on open-ended credit. But this bill came out of really a letter that I got a couple years ago from CashNet USA. They told me $1,000 is waiting for me. Good news, right? And then you have to go to this small print that I have to read my glasses to look at. And if you look really close, it says that the annual percentage rate is 299% compounded continuously. I did a bit of math and I found out that if I took this wonderful offer at the beginning of a year, I would only owe $20,000 at the end of the year. And if I still didn't pay it back yet, it would be $400,000 at the end of 2 years. These people are basically just trying to drive people into bankruptcy. They are out-of-state lenders. They are not Virginia lenders. This is not what Virginia lenders want. And so I know this is just a portion of Delegate Bagby's fine bill, but I do hope that with regards to open-ended credit, we make sure that in the final bill, we don't allow more than 36% interest, which, as I said, is really just designed to throw people into bankruptcy. So I appreciate hearing of this committee and look forward to seeing where my bill, incorporated Delegate Bagby's bill, goes. Thank you for your time, everyone.
Thank you, Delegate.
Madam Chair,
Yes.
I
Go
move
ahead.
that we incorporate the four bills, 184, 843, 1265, and 1296 into HB 789, which we will hear on Thursday.
Second.
Properly moved and seconded. Any other discussion? Register your vote on the electronic voting machine. Oh, voice vote. All in favor? Any opposed?
1265,
Thank you. So we'll hear the bill on Thursday.
1296.
Madam Chairman,
Could you, oh, yes, Delegate O'Quinn.
thank you, Madam Chairman. I guess in the spirit of administrative action, Delegate Wampler actually would like House Bill 1155 to go by for the day. I think he's still trying to get some of the stakeholders on board and ask if we'd be willing to move that by for the day. So I so move.
Is there a second? Okay. All in favor? Aye. It'll be carried over. Thank you. We're moving to subcommittee reports, but the chair of the subcommittee is not here this time. we're going to start. Okay. We have one bill, House Bill 579. It is to be carried over with a letter to Herc. Is there a motion? Second? All in favor? Motion carries. All right, we will start our docket for those who are here. And because I have nothing else, I'm going straight by the agenda. And the first is House Bill 10, Delegate Simon.
He's not here.
Not here. Is it Carter? Is Delegate Carter here? Oh, this went by for the day. Okay, the next up is Delegate Davis, House Bill 354. Not here? Is he not here? Okay. All right. Delegate Hope.
Thank you, Madam Chair. House Bill 727. And do you have a line amendment? Do you want to report the line amendment?
Madam Chair, Delegate Hope, I have a substitute.
Substitute. Do you have, yeah. I can explain the substitute without seeing it.
Madam Chair, move the substitute.
Okay. Been properly moved and seconded. Delegate, would you like to explain
Okay.
your amendment?
All right, thank you, Madam Chair. So what we're doing here is we've, on line 34, we've changed it to who's going to be the authorizing agency that's going to issue standards, and we've changed it to the Department of Criminal Justice Services, and that's changed the bill a little bit with defining what the department is. And on line 34, it's striking out the words regulations establishing. So it's they shall adopt standards for training and equipment. And so that's the changes, because we talked to some people from the agencies, and that was the most appropriate way to proceed. Let me just explain to you what the bill is about and what it does. When someone calls 911, the time it takes for paramedics to arrive can be the difference between life and death. And I think I'm talking especially to our rural members, that this is especially important and time is of the essence. So in a situation when every second counts, most people would assume that the 911 operator that you're talking to on the phone, they can know how to walk the caller through CPR over the phone. But that is not always the case. This bill would require all 911 operators by 2024 to be trained in telephone CPR. The telephone CPR is a process in which a 911 operator helps the caller identify cardiac arrest with a short script and provides just-in-time instructions on the phone on how to provide CPR. This is a cost-effective way to increase survival rates of people who experience cardiac arrest outside the hospital. So that's what the bill does. I know we've talked to a lot of the jurisdictions that already do this, but not all of them do. And so what we're saying is that we're going to give you 4 years to do it. I'm certainly open to more time if that's what the counties that haven't done this yet. But the idea is to move in this direction. A number of states are starting to move in this direction, and I want Virginia to move in this direction as well. Again, all we're saying is that you have to be trained on telephone CPR. They know how to use CPR, but there's special instructions over the phone. And that's going to be the difference between life and death. That's what the bill does, Madam Chair.
Thank you, Delegate. Any questions from the members of the committee? Yes, Delegate Marshall.
Yes, Delegate Hope, tell us about the training. How long does it take for the training, and what percentage of throughout Virginia have already had this training?
Yeah, no, it's a good question. I don't know if there's anyone here that knows the answer to that question. I do not know. Oh, you want to come up, please? I used to know the answer, but I forgot.
Good afternoon. My name is Karen Owens. I represent the Virginia Department of Health Office of Emergency Medical Services. My division within the Office of EMS oversees the Emergency Medical Dispatch Accreditation Program. We actually just completed a survey in December 2019, and I can tell you, related to emergency medical dispatch, that there are only 35 localities that do not at this time conduct emergency medical dispatch, which would be a higher level of 911 medical assistance. And that represents approximately 634,653 members of the Commonwealth, the population. The training, depending on what it is, TCPR has a certain number of hours. Normally it's between 8 and 32 hours, depending on the program.
Madam Chair?
I have another person, Delegate. Oh, is it, and for the?
It was a question for her.
Okay. Could you return your expert witness? Okay.
Yes.
Madam Chair, is it okay to ask her a question?
Yes, please
Okay, my
proceed.
question was, you said there were only 35 that were not doing this now.
Correct.
Is there any particular reason? Are there costs associated with it? Why aren't they doing it?
There are costs associated with the purchasing of the software and the equipment needed to support EMD admission and use. And each jurisdiction has had kind of a different approach. I can't speak specifically to any jurisdiction, but cost, training, and time, and the turnover of dispatchers and in and out of the position has also been a problem that we've received from them.
Further question?
Yes, please
So-
proceed.
So is this a recommendation from your organization?
No, we were not assigned the bill.
Okay.
They were not. We did meet with some agency folks, and I forget who they were, but they talked about how grant money had been set aside. This was the goal, but they felt that putting this into the code would force those remaining outliers to go ahead and start training their telecommunications. I mean, you're talking about over 8 million people in the state of Virginia, and 600,000 that represent are not covered by this. They're going to need a little push, and that's what this bill will do. And I don't know where those people are, but my guess is they're not in my area. And so I don't know if you know. Do you know exactly where they are? I mean, I just have a hunch, but I want to make sure that everyone gets covered by this.
Any other questions?
Yeah, if you want to let me go. Yes, my other question to you then would be, so is there a dedicated source of funding then, or is this a unfunded mandate? Is the grants absolutely available to these folks?
There are grants available, and so that's why I give it 4 years, and there should be plenty of money in order to do that over the 4 years. But so there are grants available, but no, we're not going to fund this. But there is resources available for them to do it.
Final question, Madam Chair.
Yes.
So if this is for software, so it's a one-time expense, so as they have people that come and go in their, as she mentioned, that you have, turnover of employees, Is the cost then already covered in the software?
So the TCPR would be slightly different than the emergency medical dispatch. When you, as an agency, selects which EMD program they want to utilize, they would get the cost. There is continued training, so they may find that they have a reoccurring cost to either retrain people as they come in or get updates to the software, which normally happens every couple of years. So it is more than just a one-time cost, but as with most purchases, that initial cost is the highest percentage of the cost of implementation.
Delegate Wilt?
Thank you, Madam Chair. You mentioned the 35 localities that don't have this. Do you know if those are, within those areas, are they paid folks or are they volunteer?
It's a mix. Some of the, I only know a few of them, so I don't necessarily want to quote in case I'm wrong or they've implemented it in the last few weeks. There is a mix of combination, career, volunteer, and combined systems that are covered by those jurisdictions that do not use EMD at this time.
Madam Chair?
Yes. You may continue.
Thank you. You mentioned the training time. You said anywhere from 8 to 32 hours.
Yes, sir.
Madam Chair?
Yes.
Is that a year, that training?
It depends on the program. As with most certification programs, there's continuing education, and it depends on the service that they use, depending on which company they've gone to. Our accreditation program that the office oversees, that is it's not a mandate or a required accreditation, does set a standard for continuing education each year, but it doesn't have a specific tie to it. But I can't speak specifically to what the requirements are for continuing education in EMD or TCPR, recognizing those would be two separate trainings.
Madam Chair?
Yes. You may continue.
So,
another question.
So along those lines, then, could you offer any idea of already the amount of training that's required for any one of these individuals already besides this training? Could you give us an idea, monthly, quarterly, yearly training that's required of these individuals?
Not with certainty, no. They do go through the academy, and I know that DCJS does set minimum standards for some of the dispatch, and if somebody else can speak to it, I will gladly let them. But I can't speak with certainty the number of weeks for an initial certification versus continuing education through their career.
Madam Chair, I'd like to speak to the measure at the appropriate time.
Okay, we have some other people who would like to speak to the bill. Have a question. That is Delegate Ayala.
Thank you, Madam Chair. I just have a comment, actually, to the patron. Thank you for bringing up this bill. In another state where my sister was suffering cardiac arrest, it was because of the training. She unfortunately didn't eventually make it, but it was because of the training that they were able to resuscitate her and bring her to a hospital where she could be cared for. Sometimes this training, and it does change in CPR. I've had CPR training. My son had severe asthma as a young child, and that training has actually changed from the time that I was certified in CPR to current times, and they advise it. It wasn't a requirement, but these could be life-saving measures that we have to keep abreast of times, and having online training or the capability of having this software so it's accessible anywhere can be imperative and very life-saving measures. So I just wanted to commend you for bringing that up to the committee.
Thank you, Delegate Ayala, because, we're talking about CPR training, so sudden cardiac arrest, the outcomes are not always good. In fact, they're usually quite low for sudden cardiac arrest, and so every minute does count. There's a reason why more than a half a dozen states have mandated this in their law. There's a reason why most, if not most, not quite all, most of the EMS dispatchers already have this training. We just need to make sure we get the rest of the state so that everyone can be protected in this way.
Any other members of the committee would like have a question for the patron? Delegate, do you have anyone with you that will speak in support of your bill?
Yes, Madam Chair.
Good afternoon. My name is Chelsea Bennett, and I am with the American Heart Association. I serve as the Virginia Government Relations Director. And so first off, thank you, Delegate Hope, for putting in this piece of legislation. Delegate Ayala, as you shared, that this bill is about life-saving measures. There are two components of this bill, as you have heard. It is the requirement for telecommunicator CPR, as well as the requirement for EMD. Each year, there's an estimated 350,000 sudden cardiac arrest events that occur in the United States. Most of them are out-of-hospital environments. And almost all of these events result in a call to a 911 dispatcher. Without the quick intervention form of CPR, death from sudden cardiac arrest is certain. As Delegate Hope mentioned, the survival rates nationwide are about 10%. 10%. So when you think about telephone CPR, telecommunicator CPR, which is a part of this bill, it's simple. When you or someone in Virginia calls their 911 dispatcher, that dispatcher should be able to provide them with instructions to perform CPR over the phone. Many of us are trained in CPR, but in those moments, that guidance can be life or death to help that individual save a life. The other portion of telephone CPR, telecommunicator CPR, that's so important is that these dispatchers are trained on whether someone is going into cardiac arrest with two simple questions. And then in 20 seconds or less, they're able to provide CPR over the phone. The second portion of this bill, as you've heard, is EMD. And so that is emergency medical dispatch, which is a higher level of training, which is where there's about 35 localities that do not provide that service. It is imperative that we think about the lives that will be saved, the lives that will be saved by both of these measurements, both of these requirements. As we talk about funding, there are grants. The Virginia Rescue Squad Assistance Fund provides grants to allow for those localities in rural areas to be able to apply, obtain the funding that they need so that their dispatchers can be trained on both of these initiatives. So again, I thank you for your time. I thank you for your attention, and I ask that as you vote, you think about the number of lives that can be saved by simply ensuring that our 911 dispatchers are able to provide the services that are needed when Virginians call in at some of the most vulnerable times of their lives. Thank you.
Thank you. Is there anyone else, member of the public, who would like to speak in support of this bill? Any member of the public would like to speak against the bill?
Good afternoon, Madam Chair. Jeremy Bennett with the Virginia Association of Counties. Just to clarify that we're not opposed to the intent of this legislation. We think that having additional CPR and EMD services for our citizens is a noble cause. We do have some concerns regarding the fiscal impact to our localities. I do have a list of localities that are currently lacking in EMD training. They range from Lee County to Lancaster, Allegheny to Fluvanna, and a lot of places in between. We have 96 localities that are currently participating voluntarily in TCPR, and as it was said, 35 localities that still need to do EMD. We've been trying to educate our membership about the benefits of this program. There is funding available through the RSAF program that does require a 50 or 25% local match of funds to receive that funding, and it is a competitive grant process that our folks would need to apply for. So we do understand that there are clear benefits for EMD service, but I just want the committee to be aware that there are local fiscal impacts that we would have to be responsible for to implement this, and localities are voluntarily trying to get to this standard. It is just a question of finding the necessary revenues to support this.
Thank you.
Thank you, Mayor. Am I allowed to ask him a question? Because we haven't spoken. Am I allowed to ask him a question? Because what the bill does is it gives them 4 years to comply. Do they need 5 years? Do they need 6 years? It's just not right that we got the counties that some of you people might represent that are not covered, and we can sit here and say, "No, that's okay." We got to at some point say, you're going to have to do this. You're going to have to join the rest of the state. And so if it's 5 years, if it's 6 years, tell us your number. Tell us what it takes to get you to make sure that people can be taken care of when their life is on the line.
Delegate, what you
want to respond?
Go on.
Yes, and ma'am, I would just say we'd appreciate as much time as possible, but even more so than time, additional state support to help us do this, especially for some of our struggling localities, would be the most beneficial. So additional funding of RSAP, additional funding for these programs would be appreciated.
Thank you. Delegate, would you like to wrap it up?
I don't think he answered my question. So I think I'd summed up already. I think it's important that we cover the entire Commonwealth. Let's join a movement that's happening throughout the country. Let's join the other states that know that this is a priority. Let's not be the last state to do this.
Thank you so much. Is there a motion on this bill, committee? It's been properly moved and seconded.
Madam Chair,
Yes.
back earlier when I was asking questions, I asked to speak to the bill.
Okay. I'm sorry.
I-
You may continue. You
Thank
may
thank
do
you, Madam
so.
Chair. And,
Uh-huh.
yeah, I'll echo the sentiments for the gentleman. I certainly don't mean to do harm to the concept, but just to voice a concern for our localities, one would guess that they, they're in that further outreaching areas. But they continue to face a struggle because a lot of them are volunteer services. They have our citizens, the folks that are working every day and we continue to require training of them and so forth, and subsequently we're getting less and less volunteers, and it's pushing our localities more into looking to paid positions, which is going to, potentially compound from a funding standpoint. So I just wanted to voice that concern, and hopefully we can,
I understand.
get it funded.
Thank you, Delegate Will.
And I do apologize, Delegate Will. I forgot you did want to make a comment. Okay, it's been properly moved and seconded. Committee ready to vote. The clerk shall close the roll. The measure passes 12-6.
Thank you, Madam Chair, members of the committee.
Up next, we have Delegate Carol Foy with House Bill 1265.
That went.
Oh, that went by. What do we have next? Just one moment.
Delegate Simons here.
Okay. Delegate Simons. I don't have it.
House Bill 10. She just said they're on.
Do we want to, or we?
All right.
Okay.
You can proceed, Delegate.
Madam Chairman, members of the committee, thank you very much. I've got House Bill 10 today. House Bill 10 is a bill that would regulate and require licensing of student loan servicing companies and create a student loan borrower bill of rights. This bill has been before this committee in one form or another, I think, for at least 3 of maybe 4 years in a row. I'm hoping for maybe a slightly different outcome this year. We have a slightly different makeup of the committee. Real quickly, what this bill does: so student loan borrowers, student loan debt is the second largest source of debt in the country, second only to mortgage loan debt. It's up around, I think when I first started giving this presentation, it was about 1.2 trillion. I think it's up to about 1.6 trillion nationwide. Yes.
Delegate, could you suspend just for one moment?
Can we, is there a substitute?
Oh.
I think there's a substitute, so.
There is a substitute, yeah, and hopefully, maybe we get a motion on the substitute. Thank you.
I'll move we adopt a substitute to get it before.
There's a second. All in favor? You can proceed
All right.
now. Explain the substitute for us.
So, Madam Chairman, what the substitute does is it makes a number of changes sort of throughout the bill to get it to where we want it to be. So I can sort of explain the substitute and the underlying bill, I think, at the same time, if that's all right with the chairman. So what House Bill 10 does is it creates a regulatory regime for student loan servicing companies at the state level. Requires them to be licensed by the Bureau of Financial Institutions at the State Corporation Commission, and then requires them, once they obtain those licenses, to adhere to a borrower's bill of rights, which gives student loan borrowers nine rights to avoid having things happen to them, and then imposes another 7 additional duties on student loan borrowers, student loan lenders, servicing companies, things they have to do on behalf of their borrowers. A lot of folks will tell you that the state need not be in the business of regulating student loan companies, that these companies, most of the servicing companies, are under contracts with the federal government, and therefore, we just leave it to the CFPB and the federal government, Department of Education, to regulate them. The problem is that the federal government really has not been exercising their authority to regulate these companies, and so what happens is we have lawsuits from student borrowers all over the country challenging some of these unlawful practices, and that's essentially the only way that these borrowers, in the absence of any meaningful federal oversight and enforcement, have to try and enforce their rights to be treated fairly. So what this bill would do is create, again, a regulatory regime at the level of the State Corporation Commission and have them licensed there. Now, there have been some challenges to the authority of states to regulate these federal companies because they have these federal contracts. So the way the bill, and the substitute in particular, gets around that issue is to create a regime for automatic licensure of student loan companies that have federal contracts. So the courts have held that we can't make them get a license and then deny them a license if they're under a federal contract. So again, the way we deal with that is they automatically get the license, but they still have to abide by our regulations here at the state level so that Virginia borrowers are protected. Let me briefly tell you the 9 things, and I'll just, like I said, very briefly tell you the 9 things that they're required to do here, because I think when you hear this list of things that we want them to do, you'll all agree that these are things that student borrowers ought to be entitled to. It says, this starts on line 229 of the bill on page 9, they won't employ a scheme, device, or artifice to defraud or mislead qualified education loan borrowers, right? I think we can all be for that. They won't engage in unfair or deceptive acts or practices towards persons or misrepresent or omit material information. 3, they won't obtain property by fraud or misrepresentation. They won't misapply qualified education loan payments to the outstanding balance of a loan. So again, if you mail your payments in, they have to apply it properly. And if they don't, you have a remedy here at the state level. You don't have to go file a suit in federal court to get them to apply your loan funds the right way. Under number 5, they can't provide inaccurate information to a nationally recognized consumer credit bureau. In other words, if you make your payments on time, and it shows up on time, they can't mess up your credit by reporting you as being late when you are, in fact, not. They can't fail to communicate with an authorized representative of your borrower who provides written authorization. This happens a lot. You have a borrower who's overseas or needs a parent or some other person to help deal with this servicing problem, or somebody who maybe there's a language barrier. They have to talk to your authorized representative on your behalf. They can't make false statements of material facts or omit material facts. This happens a lot when it comes time for a student loan borrower to try and find out whether they qualify for some sort of alternative repayment plan. There's a lot of repayment plans that are available. When you ask your servicer about that, they need to be honest with you about what your options are and tell you what all of them are, and they can't, again, omit some of the options they should have told you about, or engage in any other prohibited activities. I mean, that's your basic student loan borrower bill of rights in a nutshell. The bill obviously is fairly thick. It does a lot of other things, but mostly it all has to do with allowing borrowers those rights and having a place to enforce them against their student loan lenders. And it empowers the State Corporation Commission to enforce this, the Attorney General's office to enforce it, and also creates a private right of action for borrowers to sue in state court if they're being mistreated by their lenders. Madam Chairman, I'm happy to yield for some questions at this point. I know we have some other people that are anxious to speak probably more eloquently than I can and more expertly on this, so I'll stop there and happy to answer any questions the committee may have at this point.
Okay. Any questions from members of the committee? Delegate Mullen?
Thank you, Madam Chair. Madam Chair, I would ask the delegate, I was interested to hear about the private right of action. Can you talk to the committee a little bit more about some of the penalties that would happen if there were bad actors? I certainly have had some experiences personally with less than forthcoming information about student loans, much to my own personal detriment.
So on line 410 of the bill, you have the series of we have civil penalties of $2,500. And in the private cause of action, you can actually force them to comply with the chapter. So you can get injunctive relief, essentially, to make them do what they're supposed to do, comply with the chapter, comply with their applicable federal laws. You can sue for your actual damages, up to $500 per violation. You can get restitution of property that may have been taken against you. You can get punitive damages. You can get your attorney's fees, and then really any other relief the court deems proper. So what happens with these things is particularly that ability to get your attorney's fees back. Folks that are suffering under a lot of burdensome student loan debt don't have a ton of resources to go out and risk the hazards of litigation on their own without a lot of this protection, these options to, again, get restitution, get damages, and get their attorney's fees back. So it certainly would allow somebody to do that. And again, also actual damages, $500 per violation. Now, $500 per violation doesn't sound like a lot, but these violations could have been occurring, every time they misapply your funds and you make another payment, another payment, another payment. So I think they provide some pretty decent remedies for borrowers.
Delegate Marshall.
Delegate Simon, you mentioned about the 9, whatever you want to call them. Are you insinuating that the groups are doing this now?
I am suggesting that, yes, that is happening to Virginia borrowers. It's happening to borrowers nationwide. The evidence of that can be found, again, in numerous lawsuits that have been filed. I've got some folks, I think Seth Frotman is here, and I've got some other folks that would be happy to give you some specific examples of cases they've dealt with where that happens. But I would say all of those 9 things have probably happened to some borrower or another at some point. And I think these are not just theoretical concerns, but real instances that happen not infrequently in this realm.
Thank you, Madam Chair.
Delegate Wilt.
Madam Chair, Delegate, to kind of dovetail on Delegate Marshall's question. So do you have an idea of what percentage, I mean, you cited earlier student loan debt. How much of that debt is a result of these bad practices?
Well, so the underlying debt itself is certainly money that people borrow, but I would tell you that in some cases, the debt can double for an individual borrower. The debt can easily double if they're put into the wrong loan program or if they're put in a forbearance program, which they maybe were eligible for actual forgiveness. Because during that period of forbearance, the interest continues to compound, right? And so you can have somebody that starts out with maybe $12,000 or $13,000 in student loan debt, a relatively modest amount. They ask to be put into a loan forgiveness program. They're instead put into a forbearance program, only to find out when that program runs out that their $12,000 debt is now $25,000 or $30,000. So, I can't put a specific percentage of that $1.6 trillion that I put out there, how much that's related to these practices. I can tell you that in many individual cases, you can get up to 100% increase or more in interest as a result of having received misleading or inaccurate information about your loan options.
Delegate Head.
Thank you, Madam Chairman. Delegate Simon, looking at those 9 things again, too, because obviously we would want to make sure that those things are prohibited. And I know Delegate Marshall asking if, are they being done now? And you said they are done now. My question is, are those things not already prohibited in some other fashion? I can't imagine that any of those activities would be legal. And if they are, certainly we need to do something to shut it down. But are they not already illegal actions?
Right. So what this bill really means to do is to make these state-level offenses with state-level remedies, right? And that's what's missing right now, why this bill is important. Because these things can happen to you, and your recourse is to go to the Department of Education or to file a federal lawsuit in federal court. Right, and we've seen a lot of that, and there's been some class action lawsuits. But what this bill hopes to do is to have those folks be subject to, I ought to be able, if something like that happens to me, I ought to be able to go to the Bureau of Financial Institutions and lodge a complaint with the SEC. I ought to be able to go to the Attorney General's office and lodge a complaint and launch an investigation into those things. I'd ought to be able to go to my local Commonwealth's attorney and say, hey, I've been defrauded here by my loan servicer, and be able to get some relief that way and not have to go hire a lawyer and go to federal court and try and file a suit against this giant company that's got limitless resources and teams of attorneys to fight with me about it.
But I mean, there's nothing to prohibit them on a state level from doing this?
Nothing. This law is necessary to get state level enforcement of these things.
Thank you. Any other questions from members of the committee? Any member of the public would like to speak in support of this bill?
Thank you, Madam Chairman, members of the committee. I'm Anna Scholl with Progress Virginia. You've seen me here for several years supporting this bill, and we would urge you to support it again this year. If I could just address a couple of questions from Delegate Wilt and Delegate Head. The purpose of this bill is to ensure that student loan borrowers in Virginia are subject to the same oversight and consumer protections for their loans that are in place for mortgage lending, for credit cards, for motor vehicle loans, and other financial institutions. Right now, that is not the case. There are over 1 million borrowers in Virginia who right now owe over $41 billion in student loans, and that's a body of debt that exceeds any other consumer debt except for mortgages. It is incredibly significant, and to the extent that borrowers are not being treated well by their servicers, it's also impacting their financial futures. They're accruing more interest, they're falling behind on their payments, and it is in all of our best interest to make sure that these borrowers are able to make their payments on time without damage to their financial futures. To the question about what provisions are in place right now, the majority of student loan servicers contract with the Department of Education to service federal student loans. And the problem, which is verified in the Department of Education's own Inspector General report, is that those servicers are not living up to the obligations that they have and that the Department of Education isn't doing anything about it. And federal courts have held over and over again that states have the authority to put additional consumer protections in place for consumers in their state, and that's what we would ask you to do with this provision in supporting HB 10 to ensure that student loan borrowers in Virginia have every opportunity to succeed. Thank you.
Madam Chair, good afternoon. Fran Bradford, Deputy Secretary of Education. I'll let the smart people continue to chat after me, but just wanted to note that let the committee know that this is a bill that we have worked on with the patrons and the advocates for a number of years, and this is a bill that the governor strongly supports. Thank you.
Hi, my name is Seth Frotman. I'm the Executive Director of the Student Borrower Protection Center, and before that, I served as the Student Loan Ombudsman at the Consumer Financial Protection Bureau. I think it's important to talk about what this bill is and is not about. So this bill is not about forgiveness. This bill is not about discharging debt. This bill is not about free college. What this bill is about is making sure that the borrowers in the Commonwealth who took on debt to chase the American dream aren't ripped off in the process. And I think to the delegate's question, unfortunately, we see that this is too often the case. So just a few examples. We've seen teachers who've been promised that if they serve in a low-income community, they'll get a grant. Unfortunately, their student loan servicer lost the paperwork, and that turned into a loan. We've seen public servants, from prosecutors to social workers to nurses, be promised that if they served in their community for 10 years, they would ultimately have their loan forgiven. Now we see, because of servicers' incompetence, a 99% denial rate in that program. We've seen servicers like Navient rip off military consumer protections, where tens of thousands of service members have been denied critical Service Member Civil Relief Act protections under their student loans. We've even seen disabled veterans illegally have their credit reporting bureaus, their information set to credit reporting bureaus, making it seem like they were in default. And that's what this bill is about. It's about ensuring that if you take on debt to chase the American dream, you're not ripped off in the process. And I think to the other delegate's question, I think what this bill is about is making sure borrowers don't have to sue, because the Commonwealth has every tool at its disposal to go into these really large financial companies. Some of these companies service $400 billion of debt. And I think we just need every tool at our disposal in the Commonwealth to make sure those folks are following the law. And I think, what I've heard in my career over and over again is student loan borrowers just want the same protections as if you have a mortgage, as if you have an auto loan, and so many other products. And this bill puts the Commonwealth on track with nearly a dozen other states who've taken similar measures. So just here in support, and would love to answer any questions. Thank you.
Thank you.
Madam Chair, members of the committee, Jared Calfee with Virginia 21.
We'd like to thank the patron for his persistence with this piece of legislation we've been supporting for a number of years now. We all know that student loan debt is a major burden for students of all ages all across the Commonwealth, and what this legislation would do is offer some really basic common sense protections that we think are really important, so we don't have to rely on the federal government and have some recourse for these students at a state level. Virginia 21 strongly supports the legislation, and we hope the committee will as well.
Jay Spear with the Virginia Poverty Law Center, and we strongly support the legislation. We see a lot of these clients at legal aid offices. Thank you.
Thank you.
Madam Chairman, members of the committee, Dave Irvin with the Attorney General's Office. I'm part of our Consumer Protection section, and we support the bill as well, and have worked with the patron on some of the changes that were rolled into the substitute. Thank you.
Thank you.
Madam Chairwoman, members of the committee, my name is Boaz Youngell. I'm with the Virginia Education Association, and for all the reasons stated by the patron and by the advocates, we're in support of this bill. Thank you.
Thank you.
Hello, members of the committee. My name is Tiffany Finn-Keynes. I'm here on behalf of American Federation of Teachers in Virginia. On behalf of all of our members across the state of Virginia, we're here in support of this bill. Hiring and retention of educators in Virginia is a huge problem for our members. One of those barriers to them entering the field is because of student loans and student loan debt. So we think this is a big opportunity to help our members and future educators enter the field, and we urge you to all support the legislation. Thank you.
Thank you. Any other member of the public wish to speak in support of the bill? Any member of the public would like to speak against the bill?
Madam Chair, if it's okay, if I can yield my last word to my chief co-patron, Delegate Price, if that's all right with the chairman?
Madam Chair, members of the committee, one of the things that happened last year, but when we brought this legislation together, we assumed that members of this august body understood the process in going through student loans because we assumed they had actually had student loans. We found out that that was an improper assumption. So I just want to remind people that often 18-year-old students find themselves in compromising positions knowing that if they don't sign on the dotted line for those loans, they won't be able to stay in school, and then later they run into issues in repaying their loans. So they may call loan servicers trying to hear options for repayment, often hearing self-serving solutions to those for the loan servicers themselves. Now, last year we did make progress in creating the Office of the Student Loan Ombudsman, but that was a step in reform, and this bill, House Bill 10, would be further helping with reform. So what we need to do is protect potential borrowers before they even sign on the dotted line. And House Bill 10 would establish a better environment for these loans to exist by requiring loan servicers to be licensed and honest in their practices. And as you've heard, student loan debt is second only to mortgage debt and is essentially unregulated. So why are Virginia borrowers having to resort to lawsuits for their consumer protections? It is past time for student loan borrowers in Virginia, like me, to have common sense protections in place as we seek to finance our educational journey. And I ask that you support this bill. Thank you.
Delegate,
We have one against.
okay.
Madam Chair.
Speaking in support?
I didn't see a line forming for neutral, so if it pleases the committee, Madam Chair, Dustin Fiziak, I'm Deputy Commissioner of the Bureau of Financial Institutions. Just to clarify, the SEC does not take a position on the bill. We neither oppose nor support. We thank the governor's office and their staff for allowing us the opportunity to provide suggestions for technical amendments to the bill. However, we just received a copy of the substitute bill today. We have not had the opportunity to review it. Therefore, we are not prepared at this time to advise the committee if the legislation is enforceable, nor does the SEC take a position for or against the bill.
We have a request to speak from Delegate Bourne.
Madam Chair, I would have a motion if it's in order at this time.
Madam Chair.
Delegate Ware.
Thank you, Madam Chair. I have a question for the Attorney General's representative. Madam Chair, we've heard the assertion that these loans are essentially unregulated. Would you share that view?
We certainly believe we have the authority under current federal law to sue if there is a problem. We do not believe we have similar authority under state law. And I don't know, in terms of the private rights of action, this certainly will provide additional Virginia law where there is not law existing currently.
Any other questions from the committee? Anyone else? I see my request to speak is gone, so I'm sure everyone.
Madam Chair, I would just renew my, I have a motion.
Delegate Bourne, I see you.
I
Yes.
have a motion. If it's in order, I would move to report the bill.
Okay, it's been properly moved and seconded that the bill be reported. Ask the clerk to open the rolls. Clerk. We'll close the roll. The measure passes 15-3. Thank you. We at this one now. Okay. Delegate Delaney?
Madam Chair, members of the committee, I'm here to present HB 807. The bill before you requires health carriers and Medicaid managed care organizations. Oh, I'm sorry, let me stop myself. I do actually have a line amendment that just came in, so I'm surprising everyone with this, but it's very minor. This bill has a effective date that we would want these if it passes to become effective. The State Corporation Commission did reach out to say that because they're going to be working on some federal compliance in the spring, that they would prefer that on line 85, that I strike August 1st, 2020, and instead substitute the language November 1st, 2020, to meet agency capacity. So I did want to first introduce the line amendment, just simply changing the date.
Okay. It's been properly moved and seconded to accept the amendment. All in favor? Aye. Thank you. You can proceed with your bill.
Thank you, Madam Chair. So the bill before you requires health carriers and Medicaid managed care organizations to provide an explanation of benefits to cover persons or recipients. The measure also requires the State Corporation Commission to adopt regulations that establishes alternative methods of delivery of the explanation of benefits that permit the receipt of an explanation of benefit by an alternative method, providing that such alternative method is in compliance with the provisions of federal regulation regarding the right to request privacy protection for protected health information. These measures require health carriers and Medicaid managed care organizations to take all reasonable action to ensure that their internal process and systems prohibits the identification or description of sensitive health care services in the explanation of benefits, and requires a covered person to make a request for confidential communication in writing in accordance with federal law to accept the form of the explanation of benefits approved by the Commission. The measure also requires the Commission to define sensitive health care services, and it will affect this says 90 days, but now we've changed the date, so it will take effect on November 1st, 2020. So the issue, Madam Chair and committee members, that we are dealing with, I had asked for a study to be commissioned. The Joint Commission on Health Care took on a study that dealt with the subject of forensic nurse examiners in the Commonwealth. This was one of the findings. So this is a bill that came out of the Joint Commission on Health Care with bipartisan support. Current Virginia law requires health insurance companies to provide an explanation of benefits, an EOB, to the health care insurance policyholder. EOBs are provided after a claim for reimbursement is made, an explanation of health care services received by a person covered under the policy. The health care provider charges and the policyholder's responsibility. Yet Virginia's current law requires health insurance companies to provide an EOB to the health insurance policyholder.
EOBs are provided after a claim for reimbursement is made and explain the health care services received by a person covered under the policy, the health care provider charges, and the policyholder's responsibility. Thus, to protect their privacy, many dependents, and this could be a spouse who's a victim of domestic violence, may refuse exams and other other care services, or may request only prevention services that are free in order to avoid filing an insurance claim. So the bill before you, it amends the Code of Virginia to require the Bureau of Insurance to establish regulations and the Department of Medical Assistance Services, DMAS, to require in its contracts with managed care companies that all patients who are legally authorized to consent to care can choose a preferred method of receiving the explanation of benefits from their insurer as permitted by the code, requires the carrier to take all reasonable actions to ensure that its internal processes and systems prohibit the identification or description of sensitive health care services and explanation of benefits, and authorize the Bureau of Insurance, in consultation with experts on infectious disease, reproductive and sexual health, domestic violence and sexual assault, mental health, substance use disorders, to define sensitive health care services in the explanation of benefits. So that is the comprehensive summary of this bill, but really, in reality, this is a situation where an example would be a victim of domestic violence goes to the emergency room, has a exam done that may collect evidence that would be admissible in court. If the abusing spouse is also the policy holder, that person would then get the explanation of benefits through an email or in the mail, which puts a very vulnerable person in a potentially very dangerous situation. That could put them in a dangerous situation if that EOB came to the policyholder. It could also be a real deterrent for someone from even seeking care, knowing that they would be opening themselves up to that risk. So that's really a real-life type of example of what we're trying to solve with this legislation.
Okay. Thank you, Delegate. Any questions from members of the committee? Delegate Ayala.
Yes, I have one question, just for clarity purpose, Madam Chair. Thank you. When you talk about other means, so it could be via email, it could be however, are we ensuring that HIPAA compliance for those privacy laws are intact? So in theory, and this is just in my mind, if I were seeking alternate means of receiving an EOB, could somebody go and alter that request? So is there a preventative mechanism? So if I requested to receive email, could then my spouse go in or someone else go in and ask for a copy as well? Does it put any of those protective measures in place so that that can't be altered or?
So, Madam Chair, I do have Stephen Weiss here who did the study, and I know took a deep dive into this and may be more equipped to answer that detail.
Thank you. Madam Chair, Delegate, that's exactly what the purpose of this bill is. Right now, there is no way to guarantee that if a person wants to have it done, the EOB sent to somebody else, that it goes to that other person and that sticks. And I did run into that when I was in the Attorney General's office, where they were having a fight with an insurance company because the spouse was indeed calling the insurance company, kept changing the address over and over again, and they were going back and forth with the insurance company. I think this bill would address that as an issue.
Thank you. Delegate Wilt.
Thank you, Madam Chair. Delegate, could you just, you started through the process of how it works. Something happens, and can you finish out the process to tell us how practically that this information gets to the victim? Paint us a picture there of how it practically will work to keep the privacy. That's an issue. But yeah, that's my.
Okay. Madam Chair, I'll walk through it, and then if Mr. Weiss would like to add anything more, I'll certainly welcome him back up to the podium. So the scenario that could happen now is a victim of domestic violence goes into the hospital and has an exam done. The abusing partner is the insurance policy holder. So as things are right now, that explanation of benefits would be sent to that person, and they would then be able to see that their spouse went and had that treatment done. And that could open them up to, a lot of trouble. So that's ultimately the problem that we're trying to solve. With the bill, that victim would be able to make a request to have that explanation of benefits sent somewhere else, such that that abusing partner would not have knowledge or access to the care that they received. And it would be, my understanding would be to the place of their choosing. They could determine whether they'd like it sent to a different address or whether they'd like it sent to a personal email. They would be able to determine where they feel the safest having it sent, Madam Chair.
Thank you. Any other questions from members of the committee? Any member of the public who would like to speak in support of the bill? Anyone against the bill?
Madam Chairman, Brandon Robinson with the Virginia Association of Health Plans. We are not against the concept of the bill. We are supportive of the concept of the bill. In fact, health plans already have several measures in place to do this. However, there are some parts of the bill we want to simplify it, and we're working with the patron to do that. I think there's a simpler, easier way to get at this issue because we recognize this issue, and again, we are supportive of the concept of the bill.
Madam Chair, I have a
Yes.
question.
Delegate Byron?
Does this apply, does Medicaid get an explanation of benefits?
Madam Chair, Delegate Byron, at present, no. Medicaid does not. Medicaid members do not get an EOB. An EOB is something that comes in the commercial market.
And that's because there's no cost, right?
That's correct. That's
Okay.
correct. There is no cost to the member in the Medicaid space. The Medicaid is obviously paid through a capitation rate from the state.
And that gentleman may be disagreeing with you behind you. I'm not sure what he's standing up for, but maybe we'll find out.
We'll find out. Okay.
Thank you again, Madam Chair. I do disagree with them. We reached out to a couple of insurance companies and couldn't really get a firm answer on how explanation of benefits and member surveys are done for program integrity purposes. So DMAS, Department of Medical Assistance Services, and I did a survey of a handful of companies, probably 7 of the managed care companies, and it's a mixed bag. So there are documents going out to members, head of households from the insurance companies for program integrity purposes. And so what we're trying to address here is to make everything more uniform and consistent with all of the insurance companies and also all of the programs. Thank you.
Thank you. Delegate, would you like to wrap it all up?
Madam Chair, members of the committee, I think that, the bill before you solves a critical problem. There is a Senate companion that's moving through the Senate, so if there is an opportunity, if there's conversation that the insurance companies would like to have, I think we have some time for that to be discussed. But, this is a product of Joint Commission on Healthcare study. I think that it solves an important problem, and I look forward to the passage of the bill.
Delegate Ayala?
Yes, Madam Chair. I'd like to make a motion when appropriate.
You may proceed.
I'd like to make a motion to report.
It's been properly moved and seconded. The clerk will open the rolls, and we will vote on the electronic voting machine. The clerk will close the roll. The measure passes 19-0.
Thank you, Madam Chair. Thank you, members of the committee.
You said it was a Senate vote too, so.
Is she here? Okay. Okay. Okay, Delegate Ransom. Ready with House Bill 951.
Thank you, Madam Chair, members of the committee.
House Bill 951 is a very simple bill. It's related to how customers are notified about their insurance assessments. It seeks to amend the code so that an assessment can be sent to members by email instead of by mail. Current law states that an assessment can only be done right now by either in person or by mail. This bill simply says that mutual assessment companies can assess policyholders by email only if the members agree to being notified by email. We are basically modernizing the code. Other insurance companies are doing this already, and my understanding is that the Bureau of Insurance is okay with this bill. I hope it is the pleasure of the committee to pass the bill and make it easier for the customers and insurance companies to correspond.
Thank you. Any questions from members of the committee? Is there any member of the public who would like to speak in support of the bill? Any member of the public would like to speak against the bill? Have a question from Delegate Guzman or wish to speak?
Thank you, Madam Chair. Can the patron explain to us about mutual assessments and property casualty? What does it involve, please?
Mutual assessments. I'll let Dave Albo, do you want to talk about the different companies?
Madam Chairwoman and members, I'm representing the Virginia Association of Mutual Insurance Companies. There are basically two types of insurance companies. There are insurance companies that are funded by investors, and there are insurance companies that kind of act like a credit union where a bunch of people get together and they share risk. This is about a group, the latter, a group that shares the risk. And when they need to make a call to ask people to pay their dues or pay their fees, they have to do it by mail, and this exciting bill lets them do it by electronic.
Thank you. Delegate Wilt.
Madam Chair, what happens if the customer doesn't have some means of electronics? I guess
It's done by mail. They're
Madam
only
Chair.
going to do this if they want to do it by email.
Yes. Delegate.
I'm sorry. If who wants,
The customer.
the customer gets to choose.
Yes, Madam Chair.
Right, okay, thank you.
Would you like to wrap it all up now? I don't see a line behind you.
No, it's not life-changing.
Is there a motion on the bill? Move to report. Did I hear a second? It's been properly moved and seconded. Members can record your vote on an electronic voting machine. The clerk will close the roll. Wait a minute. Now the clerk closed the roll. The measure passes 19-0. Okay. Delegate Keem, House Bill 1149.
Madam Chair, members of the committee, can I first offer an amendment in the nature of a substitute? And it's a pretty big, thick package, but it's almost 100% technical. So,
Oh my God.
a lot of that. It's a code cleanup bill, so it's big.
It's been moved. Did I hear a second? Okay, thank you. Moved and seconded. Delegate, will you explain?
Sure. Thank you, Madam Chair, members. You may have, those who have been here for a little bit longer have probably seen these types of bills before. Virginia follows the Model Business Corporation Act for our state corporation, the Virginia Stock Corporation Act. And every time the American Bar, through its business law, makes any changes, the Virginia Bar Association, through our business law section, makes those similar changes as well as it reflects our state laws. The last big change happened in 2016. We passed a law last year that made a whole lot of different changes to update our stock laws. This year, we found some new changes that were necessary because of some laws that changed last year. Bottom line is this is a massive code update bill. I do have some members of the Virginia Bar Business Law section here who can speak if anybody is interested in hearing from the public.
Okay. Delegate Ware.
Thank you, Madam Chairman. I wonder if the patron on page 47, line 1240, if he could kind of fill us in on what that means.
Madam Chair, Madam Chair, Delegate Ware, is there a footnote to that, or is it just a, no?
I couldn't find the footnotes. That's why I was.
My version, which is a substitute, I think is slightly different than your version that you were looking at last night. I remember you're studying this at 2 in the morning, and I just want to make sure we're on the same page.
I thank the patron, Mr. Chairman, Madam Chair.
Thank you. Any other questions from members of the committee? Any member of the public who would like to speak in support of the bill?
Nobody? Mr. Goolsbee here.
Okay.
Thank you, Madam Chairman. My name is Alan Goolsbee, and I just want to assure the committee we moved through this committee in the legislature significant changes last year. These changes this year are primarily fine-tuning language coming out of revision of forms at the State Corporation Commission and the clerk's office. There are no significant substantive changes in here, and I've heard no suggestion of any concern about any of the provisions. Happy to answer any questions, but very
Thank
technical.
you. Anyone would like to speak in opposition to the bill?
Dave Babu.
All right. Okay. It's been properly moved and seconded. We will vote on the electronic voting machine. The clerk will close the roll. Measure passes 19-0. Delegate Willett. House Bill 1553.
We discussed with him, I represent debt settlement services industry, and we're working on changes of the bill, and we have an appointment set with the AG's office on Thursday. Delegate Willett told me that he was going to ask to have it carried by for the day, and I think the reason he's not here is he must believe that that was the case. So,
Okay. Thank you. That completes our agenda. However, we do have a few other bills that have been asked to go by for the day. And they are House Bill 354, 1252, and 1553. That completes our agenda. The committee will rise. We have about 5 minutes before the subcommittee begins. Give a chance for us to rearrange some things.